Welcome back to this third segment of the law session of contract law dealing with duress and undue influence. Now, just before the break, I introduced you to two classes of undue influence, which gives us three types of undue influence. We have class 1, which looks at actual undue influence, and then we have class 2, presumed undue influence. But under class 2, we have class 2A and class 2B. Now, what exactly do these mean? Well, let's consider them. In the case of BCCI and Abudi, Bank of Credit and Commerce International and Abudi in 1990, we see in that case that a husband had exerted actual undue influence over his wife in order to get her to sign a charge securing the family home on the debts owed by his company in which the husband and wife had owned shares. Now, the couple were unable to repay the mortgage and the bank sought to repossess the home. Now, the wife sought to have the mortgage set aside on the grounds that it was procured by actual undue influence of the husband. Now, the court reviewed the case and said that the husband had exerted actual undue influence on the wife. However, the transaction, they said, was not to the manifest disadvantage of the wife since she owned shares in the company. Now, in considering whether a transaction was to the manifest disadvantage, the court was to have regard to any benefits received in addition to the risks undertaken. Therefore, the bank were granted possession. Now, I want to pause on BCCI and Abudi because this was at the height of what the courts considered that how they would look at this area at the time. We will see that BCCI and Abudi is no longer good law, and there are two cases which I'll mention later on in this or in the next segment. And the fact is that if you looked at what the court said, it said they did believe that he exerted actual undue influence, but they still granted the bank possession. And the reason they did that was that Abudi requires that there be some manifest disadvantage. So they're saying, well, she had shares in it, so at the end of the day, why is she complaining? But the point I want you to take from that, of course, is that it is no longer necessary to establish manifest disadvantage in cases which involve actual undue influence. The Court of Appeal set out the class of undue influence as class 1, actual undue influence, which in that it requires proof of the influence. Class 2A looks at presumed undue influence, but looks at it in relationships as a matter of law which give rise to a presumption that influence was exerted. And under class 2B, we see presumed undue influence, but it does require proof of relationship of trust and confidence. If established, then the presumption of influence does arise. So we see one where they're saying, well, in this group, in 2A, if these people are in this group, we're assuming that there's undue influence, but in the other, you'll have to prove the relationship in order to get to that height. Interesting thing to consider on the back of that is I did raise a case, Saunders and Anglia Building Society, when we were looking at non est factum in a previous law session, and it has been raised whether or not the aunt in that case, whether it would have been, rather than raising non est factum, should she have raised some sort of pressure by way of undue influence on the basis maybe of presumed. But be that as it may, let's look at each of these. Under class 1, actual undue influence, as the name suggests, requires proof that the contract was entered into as a result of the actual influence exerted. Now, the claimant must plead and prove the acts which they assert amounted to undue influence. Now, this may include such things like threats to end a relationship, continuing to badger the party where they have refused to consent, until they eventually give in. There is no precise definition of undue influence. Now, Lord Nichols in Royal Bank of Scotland and Etridge, and this is a huge case. You must look at Royal Bank of Scotland and Etridge because it is, in my view, the case which has put, you've got Royal Bank of Scotland and Etridge, Royal Bank of Scotland and Etridge number 2, they put on a footing exactly how this area ought to be viewed. Now, Lord Nichols in the case described the concept as undue influence. He said, is one of the grounds of relief developed by the courts of equity as a court of conscience. The objective is to ensure that the influence of one person over another is not abused. In everyday life, he said, people constantly seek to influence the decision of others. They seek to persuade those with whom they are dealing to enter into transactions, whether great or small. The law has set limits, though, to the means properly employable for this purpose, and the law will investigate the manner in which the intention to enter into the transaction was secured. And he continued by saying, if the intention was produced by an unacceptable means, the law will not permit the transaction to stand. The means used is regarded as an exercise of improper or undue influence, and therefore unacceptable whenever the consent which is procured ought not fairly to be treated as the expression of a person's free will. It is impossible to be more precise or definitive. The circumstances in which one person requires influence over another and the manner in which influence may be exercised, he says, vary too widely to permit any more specific criteria. Now then, going back to the manifest disadvantage, as I said, it was a requirement originally that the claimant seeking to find relief through actual undue influence must have also established that they suffered manifest disadvantage. However, when we look at the later cases, for example, in CIBC Mortgage and Pitt, it said that manifest disadvantage was not required in cases of actual undue influence. Now let's consider Class 2A, presumed undue influence. Well, establishing the presumption, under Class 2A, there is no requirement to prove that the improper influence was actually exerted. Instead, what must be established is, 1, there was a relationship which, as a matter of law, gave rise to a presumption of undue influence. And secondly, the transaction is one which cannot readily be explained by the relationship of the parties. Now, when we look at the relationships capable of giving rise to an automatic presumption of undue influence under 2A are those of a fiduciary nature, and they do include parent and child, solicitor and client, religious advisor and disciple, doctor-patient, trustee and beneficiary. In those situations, the courts will consider that as a presumption at law that there was undue influence. So if you go to your solicitor and he says, yes, I think this is what you should do, and he makes you do something where otherwise you may not have, then you're looking at arguably your will being overborne in circumstances where the courts consider him as part of the group where you're looking at automatic undue influence. Second requirement, though, is also necessary. The transaction is one which cannot readily be explained except by the relationship of the parties. Now, where the transaction is obviously not to the benefit of the vulnerable party, but confers a great advantage to the party in a fiduciary position, the law will raise a presumption that the transaction was entered into as a result of some sort of abuse of the relationship. Now, this requirement used to be expressed in terms of manifest disadvantage, as we saw before in Abudi. It's not anymore. However, because it was expressed as manifest disadvantage, it led to confusion, particularly where a wife had an interest in the husband's business. Now, as I say, it has changed. And not least because it seemed to have set the threshold too high and certainly took account of various other considerations. Now, in NatWest Bank and Morgan, National Westminster Bank and Morgan, in 1985, a House of Lords decision, the family home was subject to a mortgage for the purchase price with the Abbey National Bank, and a second charge securing a loan of the husband's business. Now, the couple were unable to meet the repayments and got into arrears. Now, Abbey National obtained a possession order. NatWest offered a rescue package to help the couple save the home, whereby they would pay off the existing mortgage and give a bridging loan, which was to last 5 weeks for the purpose of aiding the husband's business. The manager called at the couple's home in order to explain the effect of the charge and to obtain the signatures of both parties. He was at the house for approximately 20 minutes, and only 5 of that 20 minutes was spent alone with the wife. Now remember, it was the husband's business. The husband was reluctant to leave them alone and was said to be hanging around close by at all times. Now the manager told the wife that the charge was to pay off the existing debt and to provide a bridging loan for a period of 5 weeks, which was what the bank had intended to provide. However, and it's a massive however, which is what might have gone to the way the court had decided, the actual document did not limit the amount or the time. Mrs. Morgan had told the manager that she did not want to be exposed to any extra risk of her husband's business, as she had no faith in his ability as a businessman. He knew this, the manager did. All right. You have to consider these cases factually at times. Now, the manager assured her that the risks were limited in the way he had described, and at no time did the manager advise her to get independent legal advice. It's detrimental. What you will find now, though, as a result of these cases, you do get banks in situations like these will not advance a penny until they know that both parties have had independent advice. And normally it's not unusual to see a bank getting signatures from persons saying, I have had independent legal advice. In any event, the bank later called in the charge, and in her defense, the wife said that the bank manager had exercised undue influence over her in procuring her signature. The court said that in the normal course of events, in the normal relationship between a customer and a banker, that was not one to give rise to a relationship of trust and confidence. He said Lloyd's Bank and Bondi was confined to its own facts, even though it was not expressly overruled, because something similar happened in that case. Here they said the wife had not established a relationship of trust and confidence, and therefore no presumption of undue influence could arise, not on the presumption there. But certainly the courts looked at it overall. Now, a very important case of CICB Mortgage and Pitt. In CIBC Mortgage and Pitt, Mr. Pitt wished to purchase some shares on the stock market, and he pressured his wife into signing a mortgage of £150,000, securing the family home. Now, the stated purpose of the loan was to purchase a holiday home and pay off the existing mortgage. The husband used the money, though, to purchase shares, and then used those shares as collateral to purchase further shares. For a time, the shares did very well, and he was a millionaire on paper. The wife saw no benefit from these shares, as any income was always used to purchase more shares. Now, in 1987, the stock market crashed, of course, and the bank sought to enforce a security under the mortgage, which at the time exceeded the value of the home. The wife, of course, raised actual undue influence in her defense. The court, in overruling BCCI and Abudi, said it is not necessary for a claimant to demonstrate manifest disadvantage where a defense is based on actual undue influence. However, as the transaction on its face did not seem to the manifest disadvantage of the wife, because the stated purchase was to purchase a holiday home, the bank was not put on inquiry and therefore could not be fixed with constructive notice. We will, of course, consider a class to be presumed undue influence, and we'll do that immediately after the break.